So good evening, everyone, and thank you for joining tonight's event to mark the one-year anniversary of the war in Ukraine, how the law can hold Putin to account. While I'm also a trustee of the Coalition for Genocide Response, together with our two speakers for this evening, I will be wearing my René Cassin hat. My name is Mia, and I am the Executive Director of René Cassin, the Jewish Voice for Human Rights. We work to promote and protect universal rights, drawing on Jewish values and Jewish experience. We believe that as survivors of intolerance, discrimination, persecution, and ultimately genocide, and as speakers by experience who understand the need for empathy and solidarity, the Jewish community has a uniquely authoritative voice in speaking out against discrimination and all forms of hateful and prejudiced behavior. We do that through a combination of advocacy and lobbying work and empowering tomorrow's human rights advocates. So as mentioned, tomorrow marks the one-year anniversary of the war in Ukraine, when Russia launched an illegal war against Ukraine, the Ukrainian people, and the Ukrainian entity. The UN Secretary General early today described the war as an affront to our collective conscience, a violation of the United Nations Charter and international law. Since the war started, 60 million people have been either internally displaced or found themselves as refugees. Thousands of Ukrainian civilians have been killed, and Ukrainian civilian infrastructure and assets have been destroyed. These all resulted from acts of aggression, such as invasion, attack, and occupation, which are prescribed by international laws as such that if intentionally committed by senior leaders could also constitute a crime of aggression. The same crime that in the 1945 post-Holocaust Nuremberg Tribunal termed crimes against peace, and the supreme international crime, because to initiate a crime of aggression is not only an international crime, it's the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole. It was with the establishment of the Nuremberg trials that an international legal framework of accountability was introduced, providing clear definitions of atrocities committed against people, war crimes, crimes against humanity, genocide. And through the mechanism, the tribunal itself, that enabled their application. In 2023, we have an opportunity to repeat the 1945 moment and create a special tribunal to investigate the acts of aggression by Russia and hold accountable the most senior ranking Russian political and military leaders for the crime, including Putin himself. That's why I'm delighted to have with us tonight Aarif Abraham and Dr. Ewelina Ochab, two experts in the field who are going to talk to us about the crimes and the atrocities being committed in Ukraine and how, through a special tribunal, we can hold those responsible accountable. Dr. Ewelina Ochab is program lawyer with the International Bar Association's Human Rights Institute. She's a human rights advocate, author, and co-founder of the Coalition for Genocide Response. Ewelina works on the topic of genocide with specific focus on the persecution of ethnic and religious minorities around the world, with main projects including Daesh genocide in Syria and Iraq, Boko Haram atrocities in West Africa, the situation of the Rohingya Muslims in Myanmar, and the Uyghurs in China. Aarif Abraham specializes in international criminal law and public international law, including international human rights law and international arbitration. In the past 4 years, Aarif has advised extensively and assisted on the creation, management, and operation of international tribunals and inquiries, including acting as an advisor to states, parliamentarians, and organizations. His most recent work included advising the initiative to create a special tribunal for the crime of aggression committed in Ukraine, which we'll hear about, the Uyghur Tribunal, where he acted as co-counsel and principal legal advisor, the Yazidi Justice Committee, and the Hazara Inquiry. He is the founder of the Accountability Unit and is currently practicing at Garden Court North. Ewelina and Aarif will each speak for about 15 or 20 minutes, after which we will leave enough time for questions and comments from the audience, which I would encourage you to write either in the chat box or the questions box. So without any further ado, Ewelina, the mic is yours.
Thank you very much, Mia, for organizing this important event to recognize the first anniversary of the attack on Ukraine. And as I was putting together some of the notes for today's session, I walked through the House of Commons of the UK Parliament, and I found a briefing for parliamentarians about the conflict in Ukraine, which was produced last year. And it talks about the conflict in Ukraine that began in 2014, which is something that we always need to keep in mind as well, and splits the atrocities into, of course, the annexation of Crimea between November 2013, April 2014, and then some other violations between May 2015 and October 2021. And then the current crisis is defined as the first stage between November 2021 and 23rd February 2022. And the current crisis, as it is called by in this briefing, is between 24 February 2022 and present. And this briefing, I would definitely recommend everyone to have a look at it. It should be available online on the website of the Commons Library, .parliament.uk, because it provides a very detailed overview of everything what's been happening since 2014. Just a refresher as well. Of course, today we are focusing on the 1 year of the conflict and of the war in Ukraine, but there is much more to the story. And indeed, on 24 February 2022, Putin unleashed a military attack on Ukraine without any provocation, without any credible justification. Putin's justification of the attack was clearly expressed in his speech on 23rd February 2022, when he said that the purpose of this operation is to protect people who for 8 years have been facing humiliation and genocide perpetrated by the Kiev regime. To this end, he will seek to demilitarize and denazify Ukraine, as well as bring to trial those who perpetrated numerous bloody crimes against civilians, including against citizens of the Russian Federation. This is a direct quote from his speech. He further added that we had to stop that atrocity, that genocide of the millions of people who live there and who pin their hopes on Russia, on all of us. However, those claims are to this day unsubstantiated and have been abused to propagate the attack on another sovereign country. And this act of aggression against Ukraine was followed by reports of attacks on civilians and civilian objects. Thousands of people have been killed, even more injured. Millions have fled the country and millions are internally displaced. The acts perpetrated by Putin's armies meet the legal definition of war crimes, crimes against humanity, and even genocide. And very briefly, I wanted to refer to the crimes that we may define as meeting the legal definition of genocide in Article 2 of the UN Convention on the Prevention and Punishment of the Crime of Genocide. In May last year, Raoul Wallenberg's Center for Human Rights and New Lines Institute published a legal analysis of the serious risk of genocide in Ukraine and Russia's incitement to commit genocide. And the report was based on a growing body of evidence of Russia's atrocities in Ukraine. It was supported by over 35 international experts on genocide and atrocity crimes, and made two important findings of the existence of the serious risk of genocide in Ukraine and also of the direct and public incitement to commit genocide. And the quote that I mentioned from Putin's speech from 23rd February 2022 was just a tip of an iceberg, because we've seen such incitement for many weeks and months before the attack on the 24th of February last year. And the report cites a litany of open source data in relation to both findings, including evidence of mass killings, torture, the use of rape and sexual violence. And on this topic, there've been a lot of reporting on the scale of the atrocities, with UN reporting that the youngest victim was 4, or the youngest reported victim at this stage was 4 years old and was subjected to rape and sexual violence, and the oldest in her 80s. There is also evidence of deportation of children to Russia and much more. And also the deportation of children to Russia was one of the topics that I have been following very closely because we were talking not only about children from orphanages, but also children who had parents. And also in Ukraine orphanages, some of the children have at least one living parent. And they were forcibly transferred to Russia and to be subjected to adoptions in Russia as well. And this again was supported by Putin. From what we know, the law in Russia has been changed as well to make it easier to adopt children from Ukraine. So this is something that is particularly closely to my heart, and I've been following the situation, especially of children in Ukraine who have been forcibly taken to Russia. So of course, this is just a glimpse of everything what's been happening and of the atrocities that have been perpetrated in Ukraine. But the question is, of course, what is being done to address it? And I have to say that of course, and we all know that in response to the atrocities, we've seen an unprecedented response, especially unprecedented legal responses from around the world. And just starting with the International Criminal Court, the only permanent international tribunal in existence. On the 2nd of March, 2022, the ICC opened an investigation into the situation in Ukraine following several referrals from state parties. And it started with Lithuania, followed by 39, followed by a joint submission by 39 state parties. And then also, in addition to that, Japan, North Macedonia, Chile, Montenegro, and the list goes on. And the scope for the investigation encompasses any past or present allegations of war crimes, crimes against humanity, and genocide committed on any part of the territory of Ukraine by any person from 21st November 2013. So it's not only looking at the last year, but the ICC has the mandate to look at all crimes perpetrated since 21st November 2013. And as I mentioned, also that is precisely the scope of this report produced by the Commons Library. Again, very important document. And the situation in Ukraine has been assigned to pre-trial chamber, composed of three judges, and they are to decide whether there is a reasonable basis to proceed with an investigation. What's been happening in recent months is that, for example, in May, the Office of the Prosecutor to the ICC deployed a team of 42 investigators, forensic experts, and support personnel to Ukraine to advance investigations into crimes falling into the jurisdiction of the ICC, of course, and to provide support to Ukrainian national authorities. And this represents the largest ever single field deployment by the Office of the Prosecutor since its establishment, which is, again, the unprecedented response that we've seen in response to the atrocities. And the deployment was achieved in cooperation with the government of the Netherlands, which facilitated the secondment of a significant number of Dutch national experts to the office in support of the investigations. And also just very briefly in relation to the first trip, the first deployment, on the first day of that visit, the prosecutor traveled to Kharkiv, and we all know about the scale of the atrocities in Kharkiv, in east of Ukraine, witnessing the extensive damage caused to the city and listening to the accounts of suffering endured by civilians there. And the prosecutor also met with President Zelensky and many more to hear more about the situation in Ukraine, and also to tailor their response in relation to everything what's been happening there. And the Office of the Prosecutor also established a dedicated portal through which any person that has any kind of information about the atrocities in Ukraine to be able to contact the investigators, which is, of course, to make sure that anyone from around the world, because we know that, of course, many Ukrainians were forcibly displaced, not only internally, but also to other countries. So to give them an opportunity to be able to contact the ICC, which is definitely the way forward. And so that's briefly on the ICC. But of course, as I mentioned, we've seen an unprecedented response. And then the next step that I think it's worth mentioning is in relation to engaging the International Court of Justice. And indeed, only 2 days after the attack, on 26 February 2022, Ukraine filed an application instituting proceedings against the Russian Federation before the ICJ, which is, of course, the principal judicial organ of the United Nations. And that concerned a dispute relating to the interpretation, application, and fulfillment of the Convention on the Prevention and Punishment of the Crime of Genocide, the Genocide Convention. And in relation to the Russia's claims that acts of genocide were being perpetrated in the Luhansk and Donetsk oblasts of Ukraine, which then Putin used to justify the attack on Ukraine, which is, again, I would definitely encourage everyone to look at some of the documents on the website of the ICJ, because they clarify the position and the arguments from Ukraine, and some of the responses also from Russia in relation to the proceedings before the ICJ. And interestingly, of course, as Ukraine filed the proceedings, they also requested an order in relation to provisional measures. And in March 2022, the ICJ ordered Russia to immediately suspend the military operations that it commenced on 24 February in the territory of Ukraine, and ensure that any military or irregular armed units which may be directed or supported by it, as well as any organization and persons which may be subject to its control or direction, take no steps to in furtherance of the military operation. Unfortunately, of course, as we know, Russia did not comply with this order. And in addition to those, in addition to engaging those two important international tribunals, there have been many other steps, and including, of course, in Ukraine. Ukraine's Prosecutor General Office announced investigations and prosecutions of the perpetrators from the early days of Putin's attack on Ukraine. The office set up an online portal to be used for submitting information concerning recent crimes committed in the territory. The office also created a special app to submit the data, to make it easier for people to submit it from wherever they are. And of course, this information is to be used to bring to justice persons guilty of the most serious international crimes, both in Ukrainian courts, but also in the International Criminal Court in The Hague, or any special tribunal that is yet to be created. And the office has been working also with international partners and created resources to properly document war crimes and crimes against humanity committed by the Russian army in Ukraine. And I remember last year when I was producing a briefing in relation to the different legal avenues available and the steps already taken today, that was around November last year, I remember putting a number of the crimes already registered by the office at the time. That was close to 48,000 different crimes registered by the office. And when I checked earlier today, the number was at 71,000 of crimes that have been already registered. And I would definitely also encourage our listeners to look at the website of the Office of the Prosecutor, and I can share the link in the chat in a moment, because it talks also about the number of children killed, the number of children injured, the number of different cases that they managed to register over recent months, which is with incredible precisions, and I think it's definitely something worth following. And as already mentioned, the forcible transfer of children to Ukraine, the Office of the Prosecutor in Ukraine is also investigating the crime of forcible transfer of Ukrainians more broadly, not only focusing on children, from, for example, the then occupied Mariupol and other regions under the pretext of evacuations, And I'm sure that some of the listeners know about the so-called filtration camps, which are camps where Russians put Ukrainians for further investigation, assessment, and then decide whether they are to be sent to Russia. And normally, if they are not to cause any trouble, they will be sent to Russia, or they need further persuasion to before they are sent to Russia. And the issue of filtration camps is something that also the UN has been looking into, and many others. So again, this is something that is worth looking into a little bit more. And in those filtration camps, very often Ukrainians were stripped of their documents and sometimes separated. Of course, families have been separated in those filtration camps. And other crimes recorded by the Office of the Prosecutor include, of course, rape and sexual violence, torture, the use of civilians as human shields, but also cause environmental damage and many more. And I think it's perfectly understandable that Ukraine and the Office of the Prosecutor in Ukraine is investigating those crimes. I think there was nothing unusual in that. But what is really incredible is that at this stage, at least 18 other countries have launched investigations relating to Russia's crimes in Ukraine. So, for example, among them is Germany. In March 2022, authorities in Germany announced that they opened a probe into suspected war crimes by Russian troops since the invasion. And the Federal Prosecution Office in Karlsruhe has opened a structural investigation to begin collecting evidence. And such a structural investigation does not target particular suspects, but aims to gather evidence of the suspected crimes and identify the structures behind them, such as the chain of command. And of course, those investigations are ongoing. Also in Poland, in March 2022, the Justice Minister announced that the Polish prosecutor would hold an investigation into Russia's crimes, especially the crime of aggression against Ukraine. And according to some of the statements, they've been investigating several different crimes and also collecting some evidence from Ukrainian refugees coming to Poland. And we know that at certain point there were 3 million Ukrainians who crossed the border with Poland and are trying to seek refuge in the country. So there is definitely a lot of evidence is being collected there. We know also that in Lithuania, again, as refugees were coming to Lithuania, one of the questions that was asked on the questionnaire form that refugees had to fill upon their arrival was, have you witnessed any crimes? When you come to Heathrow from abroad, one of the posters you can see as well is, have you witnessed any crimes perpetrated in Ukraine? And there is a telephone number to contact. So I think more and more countries are indeed collecting this evidence, and I'm not going to go through all of them. And another interesting development was in the US. In January this year, President Biden signed into law the Bipartisan Justice for Victims of War Crimes Act, which expands the scope of individuals subjected to prosecutions for war crimes with US courts. And this act is to strengthen the efforts to ensure justice and accountability by enabling the Department of Justice to prosecute alleged war criminals who are found in the US, regardless of the location of the crime and the nationality of the perpetrators or the victims. Important to note is that before this piece of legislation, US courts were able to deal with such crimes only if the perpetrator was a US citizen. So this bill expanded that to ensure that US courts will be able to deal also with Russian perpetrators, which is a very important development in the US. And another very brief initiative that I wanted to share is the Joint Investigation Team, which is a team of prosecutors, police and judges from different countries. And we're talking here about 6 countries: Ukraine, Lithuania, Poland, Estonia, Latvia, and Slovakia. who came together under the coordination of Eurojust to synchronize cross-border investigations and bring prosecutions to a successful conclusion. So they are working together on ensuring that they collect the information and they can index it properly and can be used by different bodies. So these are only a few of the initiatives that we've seen over recent months that seek justice and accountability. And indeed, it's an unprecedented response that we've never seen anywhere in the world. And of course, as we are very pleased that that's the response in this case, we would love to see it in as a response to other cases as well of atrocity crimes around the world. But definitely an incredible response that that we'll be following very closely on. And in my presentation, I mentioned everything apart from the crime of aggression and the response to the crime of aggression, but Aarif will do its justice in a moment. So thank you very much for listening to me. And if there are any questions, I will try to help.
Thank you, Ewelina. Brilliant segue to you, Aarif.
Thank you very much. And may I firstly begin by thanking René, Cassin, and Mia in particular for the invitation to speak today. It's an honor being here with Ewelina and especially on this special anniversary year of the Universal Declaration of Human Rights. What I propose to do is to use the short time that I have to make 3 points. Firstly, outline what the definition of the crime of aggression is, and how it is distinguished from acts of aggression, and why accountability for the crime of aggression can only be ensured by a special tribunal. Second, I will briefly discuss the history and precedents behind the crime of aggression. And third, I will explain the practicalities of the creation of a tribunal and the 4 major and largely political critiques about creating a special tribunal, which relate to the idea that a tribunal would be in competition with the International Criminal Court, criticisms about immunities for serving heads of state, the idea that a special tribunal might constitute a selective form of justice, and finally, whether a tribunal may set a dangerous precedent for the future. Ewelina has already talked about the current legal accountability landscape, so I don't propose to go over that, except to say that during this ongoing armed conflict, as Ewelina has noted, there has been a very widespread commission of crimes by individuals affiliated to Russian state agents, organs, or officials, including its armed forces, which could constitute, and in some cases has constituted, war crimes, crimes against humanity, and presents the possible risk of genocide. So who has authority to investigate these crimes and hold those who commit them responsible? Well, over war crimes, crimes against humanity, and allegations of genocide, Ewelina noted that the International Criminal Court has had jurisdiction ever since Ukraine self-referred the situation there on its territory to the International Criminal Court in 2014. And this has meant that all such international crimes committed since November 2013 on Ukrainian territory, where it concerns high to mid-level perpetrators, can be prosecuted by the International Criminal Court only where Ukraine is unable or unwilling to do so. That means Russians, Ukrainians, in fact, anybody of any nationality committing crimes on Ukrainian territory could be held accountable. And of course, Ukraine itself has mobilized a vast investigation and prosecution exercise through its domestic court system to prosecute war crimes. So what crimes are not within scope of any formal international court tribunal or mechanism? Principally the crime of aggression, which brings me to my first major point. Russia's use of force against a sovereign Ukrainian state constitutes one or more illegal acts of aggression contrary to binding international law, having not been authorized by the UN Security Council, and these acts not being an act of self-defense. As such, this constitutes a violation of the prohibition on the use of force and territorial conquest, as well as the prohibition on committing acts of aggression incurring the international responsibility of states. Aggression is also considered a crime, incurring individual criminal responsibility of leaders, and as such, those leaders exercising control over or directing political or military action of the acts, in the words of the Nuremberg Tribunal, are committing the supreme international crime. But for the crime of aggression in the Ukrainian context, you would have no war crimes, crimes against humanity, or allegations relating to genocide. What precisely do we mean by the crime of aggression? Well, the crime of aggression means the planning, preparation, initiation, or execution by those exercising effective control over or directing the political or military action of a state of an act of aggression, which by its character, gravity, and scale constitutes a manifest violation of the Charter. And that's the Charter of the United Nations. What is an act of aggression? Well, it means the use of armed force by a state against the sovereignty, territorial integrity, or the political independence of another state in a manner inconsistent with the Charter. And there are acts of aggression which are specified. I don't have the opportunity to go into all of them, but in summary, they include invasion or attack, bombardment, blockade, attacking the armed forces of one state by the use of the armed forces of another, allowing one's territory to be placed at the disposal of another state to carry out acts of aggression, or the sending by or on behalf of a state armed bands, groups, irregulars, or mercenaries. As aggression against Ukraine continues, there is no international body before which those responsible in Russia or Belarus for this crime can be brought, which brings me to my second point. What are the origins of the crime of aggression? Lest we forget, the crime of aggression is not a principally Western construct, and the Soviet Union, thanks to the conceptual work of Russian jurist Aaron Trenin, was actually the major player in insisting on its prosecution as a truly international crime. In fact, on the 1st of November 1943, as the Second World War was raging, the Soviet Union, the United Kingdom, and the United States issued the Moscow Declaration, and it said, and it gave, and I quote, full warning to the Nazi leadership of the Allies' intent to pursue them to the uttermost ends of the earth in order that justice may be done. And indeed, in the first set of trials at Nuremberg, all 22 senior Nazi leaders were tried with conspiracy to commit aggression, and 8 of those were convicted, and 16 were charged with the crime of aggression proper, and of those 12 were convicted. So how was the Nuremberg Tribunal able to try the crime of aggression, and what sources might we look at today for creating a tribunal for aggression? Well, states are able through treaty to provide legal and enforcement powers to new institutions, either through multilateral treaties or treaties with international or regional organizations. That is exactly what the Allied states did by coming together to create the Nuremberg Tribunal. In the words of the judgment, they have done together what any of them might have done singly, for it is not to be doubted that any nation has the right thus to set up special courts to administer law. As to the source of the crime, the Nuremberg judgment traced and documented the international and customary origin of the crime, and reiterated that the consequences of aggressive war were not confined, and I quote, to the belligerent states alone, but affect the whole world. So in relation to treaty precedents for the creation of tribunals, there are at least 25 relevant agreements that I've identified since the 1929 Kellogg-Briand Pact, which is often cited as the precedent for the prosecution of the German and Japanese leaders after the Second World War. Of those, 10 are particularly relevant, and I sadly don't have time to go into them today, but I'll just mention a few. Of course, we have the 1945 Charter, an agreement on the international military tribunals, which tried Japanese and German leaders. We then had a massive gap during the Cold War, and it was not until 1993 and 1994 that the tribunals on Rwanda and Yugoslavia were created through authorization by the UN Security Council. In 1998, of course, we had the Rome Statute, which set up the International Criminal Court, and that was the first major international instrument to deal with the crime of aggression since the Second World War, following the 2010 Kampala amendments. And there have been various other courts. In 2002, for instance, there was the Special Court on Sierra Leone. In 2003, an agreement between the UN and Cambodia on the extraordinary chambers, and there are various others. Now, the majority of these precedents dealt with a range of international crimes, and only 2 substantively address the crime of aggression, but they all helpfully point to possible means and methods of creating a special tribunal. Which brings me to my third point: how would a special tribunal be created? Now, a special tribunal could be a strictly international tribunal set up upon recommendation by an international organization or through a multilateral treaty. Or alternatively, it could consist of a hybridized chamber within the Ukrainian court and justice system. And an example of that would be, for instance, the extraordinary chambers in the courts of Cambodia, which was created upon recommendation by the UN General Assembly. Or alternatively, it could be what's called a freestanding or an internationalized hybrid tribunal. And an example of such a court would be, for instance, the Special Court for Sierra Leone, which was created by the UN Security Council, but not under its Chapter 7 International Peace and Security mandate, but rather under Chapter 6. Where would jurisdiction for a tribunal be derived from? Well, it could derive from Ukrainian law, which proscribes the crime of aggression. Incidentally, so does the Russian and Belarusian domestic statutes. And the jurisdiction would be read together with the prohibition on aggression under customary international law, or alternatively, it could also be derived from pooling the universal jurisdiction of other states, which Ewelina had mentioned. The creation of such a tribunal is no longer academic. Over the course of the past year, following a proposal by Professor Philippe Sanz QC in February of 2022, we have moved from the Ukrainian government and Eastern European countries taking the lead on supporting and calling for a tribunal to a tribunal now being publicly supported by the European Commission, the Council of Europe, and major powers including the UK, France, Germany, and the Netherlands. Many others are also in support privately. So the question really is not if a tribunal will be created, but when and how. So what are the key criticisms and apparent stumbling blocks in respect of creating a tribunal and prosecuting leaders in Russia and Belarus? A common critique is that it would somehow compromise the work of the International Criminal Court. Well, firstly, the International Criminal Court has no jurisdiction for aggression and in the Ukrainian context, and only has jurisdiction since 2014, as I've mentioned, to try other international crimes. Second, Russia is not a state party to the International Criminal Court, and membership, as well as ratification of the Anti-Aggression Amendment by both parties to a conflict, is the only consensual way the International Criminal Court would have jurisdiction. The non-consensual alternative is a referral to the International Criminal Court by the UN Security Council, which of course would be vetoed by Russia. So in essence, there is no international body before which officials of any sort may be tried for this original sin, if you might call it that, the crime of aggression, because it's from that from which all the other harm and crimes in Ukraine have flowed. And it is because of this vacuum, a special tribunal would help enforce binding international law relating to aggression and would be complementary to, rather than in competition with, the International Criminal Court or the International Court of Justice. The second concern is that immunities will apply to Russian or Belarusian leaders if brought to trial. Now, it's important to understand what immunities precisely mean. First, state officials are ordinarily immune from prosecution in the courts of foreign national states for acts done in an official capacity, for the obvious reason that they could put at risk the ability of states to have diplomatic relations with each other. There is a strong view, however, that there is an exception for functional immunity for international crimes, even in foreign national courts. Second, ordinarily, serving high officials, such as heads of state or heads of government, enjoy personal immunity from prosecution as long as they hold office. Again, an exception over time has developed for personal immunities of serving high officials before, and critically, international courts or tribunals for grave international crimes. And this would be the case for crimes against humanity, even though there is some academic debate about it. As such, an international tribunal can overcome the immunity hurdles, and there is precedent for that coming from decisions of the International Criminal Court, the Special Court for Sierra Leone, and the International Court of Justice. So essentially, if any of the models I've discussed are being considered are sufficiently international, and again, there is some debate about this, especially in respect of a hybrid tribunal, then any issue of immunities for serving high officials would be less than arguable. Third, there is a critique that the idea of creating this tribunal for Ukraine is somehow selective justice or may constitute double standards, particularly on the part of the West. And that's, of course, in light of the failure to prosecute crimes of aggression committed elsewhere, and of course, the elephant in the room being Iraq. But it is important to note, however, that the call for a tribunal has come from Ukraine. Its consent and cooperation are being offered in full, which distinguishes it from other states in which serious international crimes have been committed with impunity. Ukraine has an inherent right to self-defense under international law and to use all lawful means, including deadly force, in response to the attack from Russia. Creating a special tribunal is, of course, one such means, and certainly less lethal than the use of armed force. Also, Russia's actions against Ukraine are arguably one of the first to meet the very high threshold I've mentioned, which is built into the definition of the crime of aggression, and which was only agreed by International Criminal Court member states in 2010, although it has older roots in custom. So really the answer to the selectivity critique is not to deny justice for Ukraine, but to advocate for future amendment of the International Criminal Court statute to remove these jurisdictional restrictions that are unique to the crime. Finally, there's this suggestion that somehow the creation of a tribunal would set a dangerous precedent. Well, first, it comes as no surprise to say that since 2010, the International Criminal Court has had jurisdiction for the crime of aggression, but that jurisdiction critically was curtailed by a number of major powers. In an ideal world, an International Criminal Court with strong jurisdiction over the crime of aggression, applying widely to every state in the world, would have prevented the current situation we are in Ukraine. But we do not live in an idealized world, but one in which we make practical decisions informed by ideals. A domestic or highly domesticated tribunal is precluded and would not be desirable in any case. And the crime of aggression, by its nature, is international and requires an international response rooted in the general prohibition under international law. Such responses, I argue, are rare. A UN General Assembly condemnation by a majority or a supermajority is not an easy exercise in diplomacy, and neither is the extremely tough work of creating a legitimate tribunal in line with accepted international norms and principles governing human rights. If such a precedent is created, then surely it would be a good thing. But to reiterate, this special tribunal will not create a precedent as such for other states, although it will fill a gap in international law. It will give renewed impetus for support for the International Criminal Court to expand its jurisdiction, and it will serve as a symbolic lesson to other states contemplating aggressive wars, which are, as I have already said, in violation of customary international law, as well as the Rome Statute. So to conclude, I would like to highlight why a special tribunal now for the situation in Ukraine is so important. A lean, bifurcated, and highly international model, separating out prosecution work from eventual in-person trials if perpetrators are apprehended, could start the work of critical contemporaneous evidence gathering immediately and at low cost, given the singular focus of the tribunal on a narrow clique of perpetrators for a single crime. That work has already begun by the announcement by the Dutch government in concert with the European Union to set up an international centre for prosecution based in The Hague, and that work has already begun. Second, the creation of a tribunal is the surest and quickest route to trying Russian and Belarusian leaders for international crimes. Trying senior leaders for war crimes, crimes against humanity, or genocide is notoriously difficult because of the difficulty in linking crimes committed on the ground by troops to senior military or political figures who are often well aware of the risk of having crimes attributed to them. and it would take many years, if not decades, although that track must still be pursued. Third, such work could deter perpetrators from further aggression, both in Russia and Belarus. It would moreover reinforce the idea, a fundamental idea, that the prohibition on the illegal use of force and the crime of aggression is important, as is international rule of law. And in the Russian context, given its previous legal attacks, invasions or interventions in Georgia, Moldova and Ukraine itself, that is critically important. Fourth, the international nature of a tribunal would reassure the international community of impartiality and overcome complicated issues relating to immunity of serving heads of states and government. And fifth and finally, a tribunal would signal the disregard in which aggressor states are held by the international community, and in particular in Europe where this crime is occurring. States ought to put aside their short-term domestic interests and put at the forefront the rule of law and international justice. And that's why many of these instruments and institutions we are discussing were created in the aftermath of the Second World War. Support for a special tribunal will do just that and make war making that much harder in the future, both in Europe and further afield. Thank you very much.
Thank you very much, Aarif. I hope everyone will join me in saying that this has been very much eye-opening, and I think the resonance with the civil societies or the international response after World War II and the horrors committed in the Holocaust and the need to set up a system are bearing fruit today. And yes, there are gaps in that system, and we've identified one of them, but the international law that we take for granted and we use as a mechanism wouldn't have been set up had it not been to the response in the first place to the acts of aggression and crimes against humanity. This is now time for our audience to ask questions. I'm going to take the privilege of asking the first question to enable our audience to take some time and think about others. Aarif, I asked you this question before. A tribunal is set up. Putin is not going to waltz in to the court and say, try me for all my crimes. What is the point beyond just the precedent of creating the tribunal? Could Putin and other senior officials be tried in absentia?
Thank you, Mia, for the first question. It's a good question. Essentially, almost all serious advisors on this issue, on creating a special tribunal, are generally very hesitant and against the idea of in absentia trials. The reason being is, of course, that you could spend a huge amount of money and do a huge amount of work in respect of trying to investigate and prosecute someone who may never appear before the court. And we've had bad examples, one such example being the Special Tribunal for Lebanon, where we had very costly trials without any defendants. And of course, if you are to abide by international rule of law standards, then if a perpetrator is apprehended, then of course they would have a right, an inherent right to a fair trial whilst being present during that process. So essentially you would be doing the whole thing again if they were apprehended. And it's for those reasons that in absentia trials are generally seen as not being an ideal or best practice. So that brings me to the second part of this question, is what would happen if they're not apprehended? Now, as we know, if you do not have mechanisms, if you do not have a court or tribunal, there would be nowhere to send a perpetrator, which means that even if, let's say, the political situation was to change in Russia one day, absent a special tribunal, there would be nowhere to send somebody who had committed the crime of aggression to be prosecuted and be held accountable for that crime and given its gravity and nature. And finally, we ought to look at precedents. So if we look at precedents for previous international courts or tribunals, from Nuremberg all the way to the present day, it often took many years, if not decades, for perpetrators to be apprehended. If we think of Radovan Karadzic if we think of Ratko Mladic, each of them took almost a decade to be apprehended. If we look at Milosevic, the tribunal for the former Yugoslavia was already set up and running for almost 20 years before he had been indicted for crimes. And he was indicted for crimes when the political situation changed in Serbia. And eventually he was given up. And then we've got other examples. We had the attempted trials on Pinochet. We have the Eichmann trial, which of course we all know about and have read about. And we have recent cases as well, such as Hissène Habré, who was brought again before a special tribunal, a special court, again, many, many years after crimes were committed. So essentially, the creation of a tribunal gives that hope and possibility of future execution and fair trials.
Thank you. We've got two questions from our audience, I think partially answered. I think the first one probably more relevant for you, Aarif, the second one more relevant for you, Ewelina. So the first question is, a special tribunal, where would it be located? So I think you mentioned the Netherlands. And judges appointed by whom? Powers of punishment. So that's a question to you, Aarif, I think. And to you, Ewelina, how do you think it's possible to resolve the issue with Russia today from the point of view of international law? And how can we effectively apply the mechanisms and the structure we have in place in the most effective way? Ewelina, do you want to go first, maybe?
Yes, I'm looking at the question and how can we resolve the issue. So obviously we mean the war and the conflict, which is not an easy issue. I think there've been certain discussions in terms of whether a peace agreement would be possible and what it would involve, and of course, and we've seen lots of different commentaries in relation to this. For example, what Putin would ask for in order to even consider a peace agreement, and what that would mean for Ukraine. So I think all those concerns have to be taken into consideration, and of course we would like this war to end as soon as possible. Over the last year, we've seen way too much suffering and horrific atrocities against civilians. But at this stage, at least I don't see this resolving anytime soon. Definitely something what we need, but as we are hearing more and more threats from Putin, and including to use nuclear weapons against the West, I don't see any solution anytime soon.
And just on the question of where a tribunal would be located, the Dutch have offered to be the host of such a tribunal. And so, there's a bit of an echo from somebody. So yes, so it's quite likely that if a tribunal is created, then of course the Dutch are taken up on that offer, given the synergies with the fact that most international tribunals since the Second World War and obviously since the 90s have been set up and based in The Hague, and obviously that's a natural location in what's called the City of Peace for a tribunal to be located. It's being backed, as I've said, by the European Union quite heavily. The new International Center for the Prosecution of the Crime of Aggression, as allegedly being committed in Ukraine, has already been created it's been set up in The Hague under the auspices of Eurojust, which is an EU institution. So all of that points to the Netherlands as the possible host of a tribunal, and that will be subject to agreement. And on the issue of an agreement, that's where complicated questions about how judges are appointed, what would be the powers for a tribunal, what would be the procedural rules, all of those are set out in two documents. First is called an agreement, the second is called a statute, and then the third is usually a rules of procedure and evidence. And there are plenty of precedents for that from 93 onwards, and there is now a lot of best practice in respect of what is the ideal for the appointment of judges, how does a prosecutor's office work, how are indictments issued, who approves them. So all of these are technical aspects which I can assure you people are working on.
Aarif, is there a threshold of a minimum number of countries that need to sign the treaty or the formal establishment of the International Tribunal?
Yes, I saw there was a question, a very good question, about the fact that when I mentioned that there is a problem of immunities, that is overcome by what's known as an exception to the personal immunities issue. So ordinarily, if you're a head of state, a head of government, a foreign minister, essentially those people that might be being considered for violating the prohibition on the crime of aggression, they ordinarily can't be brought before a court unless, and this is where the jurisprudence comes in, it's an international court or tribunal. Now you're going to ask, well, what does international really mean? And the courts are relatively non-prescriptive on what the technical requirements are. They've just said that this tribunal or this court is international in nature. It has an authorization coming from an international organization such as the UN Security Council. It is applying international law. It has international judges and prosecutors, and therefore this is international, sufficiently international for the exception to apply. Now you might say, well, how many states makes it international? Is it 10 or 20 or 30 or 40? We don't have an answer. And of course, that will be an issue for a possible defendant, if brought before a tribunal, to say, look, actually this court, it's a kangaroo court. It's been set up by four states, and we're not going to, we don't believe we could be tried here because it's not international. So there is significant, let's say, academic debate about this. And of course, in an ideal world, we have a tribunal that's created by as many states as possible, on as many continents as possible, giving support, and ideally through the auspices of the UN General Assembly, absent a UN Security Council resolution. And that would require either a majority or, if it was a uniting for peace resolution, a supermajority of the UN General Assembly, which is of course a very large number of states.
We have another question. I think Ewelina, probably in the back of the event that you and I attended in Parliament just earlier this week on the anniversary, that I guess is the £1 million question. What can be done to ensure the war ends faster so that all of the crimes and the atrocities that are committed not only end, but then that international law can step in and hold those accountable, responsible for them?
Yes, it is a $1 million question, £1 million question. Indeed, what can be done? A dialogue, but with Russia, trying to accommodate it somehow, which is the usual response that we often hear, but ultimately it's more difficult to accommodate than one would think. And indeed, whenever I work with many politicians here at the UK Parliament, and whenever we table questions in terms of what have been the communications with its Russian counterparts in relation to the atrocities, in relation to everything what's been happening, but the response is that the dialogue is pretty much not there. There is no dialogue with Russia at this stage, and we need to keep in mind that, of course, even the UK received lots of threats from Russia if the UK continues to be involved in terms of providing weapons, providing ammunition and so on, and also few British fighters were also caught, convicted, and faced at some point death penalty, from what I remember. So the relationship between, for example, the UK and Russia is very, very difficult. It's fragile, non-existing at this stage. So the UK is not in a position to help with accommodating such dialogue. What was interesting that happened some months ago was the dialogue that was accommodated by Turkey out of all the countries, and we know Turkey is also involved with lots of human rights violations, but ultimately Turkey accommodated dialogue between Russia and Ukraine in terms of grain that was to be shipped to many African countries. So that was a very interesting development, and also came with lots of challenges. It wasn't as easy as one would think that Turkey managed to bring those two countries together and made an agreement, and we know that there were also it backfired at certain point, and so anything that that countries can do is very, very challenging at this stage, and we need to recognize it. But ultimately, of course, there's so much unity between countries in supporting Ukraine, and so hopefully that will be the way forward. And the pressures that countries also impose on Russia in terms of even sanctions will bring some kind of response and effect. But this is something that one can hope. But ultimately, it is a massive challenge that there seems to be at this stage not much that we can do.
Thank you, Ewelina. Not encouraging, I think. Message that we're all hoping. Aarif, final words from you before we close the evening?
Thank you, Mia. I mean, I noticed there was an additional question, and Ewelina's partly answered it, is this idea of what is it that we can do now, and is the end in sight? And of course, this conflict has been raging now since 2014, and it has earlier precursors. Of course, we should try and support all of these initiatives that are being undertaken, partly because they are Ukrainian-led, and there is a sense that we are somewhat diffuse and far away in this conflict. There are states which feel an existential threat from the acts of aggression in Russia, and that means that we ought to have systems and structures in place which not only give the hope of accountability and justice in the future, but have an impact right now, deterrence impact on further aggression, an impact on possible negotiations which may materialize, and many specialists say that now is not the time for ceasefires where there are raging acts of aggression, including the commission of international crimes. And of course, there is an inherent right to self-defense. And so whilst the conflict rages, of course, creating the conditions for future accountability and justice is, as lawyers, one of the most hopeful and actively hopeful things we can do. And I'm glad to have been part of this conversation today in trying to help that.
If I may very briefly add, something what Aarif just mentioned, and so we need to always keep in mind, 2014, and the impunity for what was being perpetrated then, that and of course what happened last year, the new attack on Ukraine. This was all preventable. This was all predictable. Especially in atrocity prevention, we talk about early warning signs as factor, and impunity is one of them. So I think we need to also be mindful of such risk factors, early warning signs of future atrocities, and take responsibility for the responses that we engage in relation to such acts. So 2014 was a missed opportunity also on justice and accountability. Something to keep in mind. And again, all is in the report from the Commons briefing as well.
Thank you both. Really powerful analysis and presentation of the situation. I am determined to try to end this discussion in a positive note. Aarif mentioned this year is the anniversary of the Universal Declaration for Human Rights. It was drafted by our namesake, Monsieur Cassin, in the aftermath of the horrors committed in the Holocaust, but actually started in 1945 with the introduction by two Jewish lawyers themselves of phrases of the beginning of international law, crimes against humanity and genocide, that we are now 78 years down the line able to use as a definition to crimes committed against people, but also with the tools to hold the perpetrators accountable. This didn't exist 80 years ago, otherwise the Holocaust wouldn't have happened. So a lot of progress has been made, and I think we as individuals, civil society, politicians, lawyers, really have the responsibility to make sure that the mechanisms are set up and perpetrators brought to account, so that the next 75th anniversary of the Universal Declaration for Human Rights is a pure celebration of success. We're half there, but we still have a long way to go. We have a series of events hosted by René Cassin to mark the anniversary, so please watch our space. And if you enjoyed today's session, please sign up to our newsletter, become a friend and supporter in more than one ways of René Cassin. And I look forward to seeing you in future events. And I hope you'll all virtually join me in a virtual clap. And thank you to Aarif and Ewelina for this evening. Thank you very much.
Thank you, Mia. Thank you.
Thank you very much.
Thank you.
Bye.